Barton raised some defenses at the last hearing 2 weeks ago. We instructed him to file an answer to the complaint. I never received that. Yesterday, I called my assistant called the court, and we saw that he did file something yesterday or the day before. So the clerk here was nice enough to email the answer to me. I got it up yesterday. There's a lot of allegations in there.
Yes.
Mr. Potter, I did also get the answer emailed to me overnight after midnight, and apparently he taped something in this case, which I believe is the answer to a loading dock door at Dobbins Farms where my office is. I just got that notice when I'm sitting in court here. Basically, in his response, he admits that he has vacated the premises. He's abandoned the property. He's done that since the beginning of July.
Can I reject that? That's nothing like what I said in my statement.
Oh, well, okay. Let me just, because that's what I kind of gleaned from this. Are you in the property or not? Pardon?
House is filled with mold. The water filtration system has been disconnected and the pipes are still leaking into the base. Trying to get my stuff out of there as fast as I can. Working on it.
Okay, so you're not living in there, but you have property there. All right.
It's covered in mold. So in order to move it, it needs to be cleaned before I can bring it into my new house. And I got a staph infection from dealing with all the mold. That's why I was late turning in the paperwork. I have a doctor's note, easy clean.
So, Your Honor, the most important thing here is that my client get access to the house to remediate the problems that are in there. There's no debate that there are problems. How those problems are caused, those are up for discussion because we believe that defendant significantly contributed to the mold problem by not allowing access, not allowing remediation. So, Your Honor,
Okay, look, this is not a trial. So the whole objection thing that you see on TV, not helpful.
As the discussion continued, the tenant strongly denied blocking access to the property, stating that the landlord had keys the entire time. He accused them of entering the house and leaving doors and windows open, causing rain damage to his personal belongings, including furniture and electronics. He claimed repeated negligence led to further destruction inside the home. The judge cut through the back and forth and focused on one clear question. Did the tenant object to the landlord entering the property to begin remediation? When the tenant said no, the judge authorized entry with proper notice. The landlord was permitted to enter the home to remediate damage, protect the property, and move items only as necessary, without throwing anything away unless the court later ordered it. The case was then scheduled to return in 2 weeks for further review.
You wait till I tell you you can talk. Go ahead.
So what we're looking to do, my client has notified his insurance company about this whole problem here. And they said they're actually going to drop him by the end of the month if he does not get in there to remediate the problems. So what I guess I can do under the lease, if he's not saying that he's moving out or moving out his possessions, to the very least, I can exercise some language under the lease that says that we can get in there with 24-hour notice to the tenant. So we're giving 24-hour notice to tenant that we will be in there on Monday morning to start remediating this. And his possessions in there, you can see that it's quite cluttered from the pictures that were attached to his answer. Some things are going to get moved away from the furnace and other things that need to be repaired. We will not throw anything out until further order of this court, but we are going to be getting in there to remediate this immediately.
Go ahead, sir. What do you want to tell me?
I never prevented them from access to the house. They've got keys to it. The lock is the same. The only thing I did was disconnect the garage door because every time I kept coming over there, it was wide open with all my stuff there for somebody to take.
Okay.
I also went into the house, all the windows, left all the doors unlocked, and a lot of my stuff got rained on now the last couple of months. And that's been ruined upstairs where there wasn't even a leak from the pipes. That's also shown in the picture.
What, they left the windows open?
Lock all the doors, turn all the lights on, and pull the screens up, open all the windows, and not rain inside the house, Your Honor. My couch is now ruined. I've got a laptop that's ruined. A bunch of other stuff got wet. And this has been going on since
Okay, so in terms of their notice that they're entering the premises to remediate, you don't have an objection to that. Didn't ask you whether you ever did. Listen to my question. I don't need the superfluous language. You do not have an objection today, correct, to that? All right, they will be entering the property. They will be able, for the purposes of remediation and protection of property and preserving the property pursuant to the court rule, I think it's 4.201H. And you are not to destroy or remove any items except by order of the court. All right. So if you want to prepare an order to that effect, which we may need one just in case, I certainly would appreciate it. And then when do you guys want to come back? Because you're going to have time to review thoroughly the answer that has been answered and presumable counterclaims. 2 weeks, will that work for you, sir? During this matter, November 4th, 2025, 1 p.m. November 7th. I don't know. Why am I writing the 4th?
Because it was a Tuesday date?
Oh, you're right. 1 p.m. Okay, so I haven't completely lost my mind. All right. Thank you.
At today's hearing, tensions were already high as the judge addressed a growing dispute between a landlord and tenant over a severely damaged rental property. The issue began when the landlord's attorney explained that although the court had ordered the tenant to file an answer to the complaint weeks earlier, it was only submitted at the last possible moment. When the answer was finally reviewed, it revealed serious allegations involving mold, water damage, and abandonment of the property. According to the tenant's own filing, he admitted that he was no longer living in the home, though he still had belongings inside. The tenant claimed the house was filled with mold, the water filtration system had been disconnected, and pipes were leaking into the basement. He stated that moving his belongings was difficult because everything was contaminated and needed cleaning before it could be transferred to his new residence. He also told the court that he had suffered a staph infection from exposure to mold and provided a doctor's note explaining his delayed court filing. The landlord's attorney emphasized that the most urgent issue was gaining immediate access to the property. The landlord's insurance company had warned that coverage would be canceled if remediation did not begin by the end of the month. While responsibility for the damage was still disputed, the landlord argued that delays in access had only made conditions worse. This hearing, the judge reminded everyone, was not a trial, but action was clearly needed.